The chair recognizes the distinguished chair of the House Judiciary Committee, Chairman Willard, to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, let me start out giving you some numbers that might cause you to stop and realize the problem we have in Georgia with our juvenile justice system. Currently, if we take a child and put them into what we call a secure detention, that child is going to cost the state over $90,000 a year. You can put children through the finest college in this country for less cost than that. The other bad thing is that of those children we take into detention and become part of our juvenile system, 65% recidivism within a 3-year period of time. And the fact that the ones that we have serving now, probably 40% from the statistics we have, are there for really what we call misdemeanor type offenses or status offenses. Status offenses being those things such as a truancy, run away from home, things that would not be really considered a crime if done by an adult. I want to give you some overview. I'm going to try to be as quick as I can, but it's a very important piece of legislation. This bill has been in the process for the last 5 years. It started as a program really by the Young Lawyers Division of the State Bar as a rewrite of the Juvenile Code to make it more understandable, because over the years since its first adoption in 1970, as amendments were made, things were changed, put in different areas, and became very convoluted for the practitioners in the field as well as the judges to try and follow procedures that would be applicable to the Juvenile Code. Last year, those who were serving will recall we had a bill come through, House Bill 641, which was also the juvenile bill. That bill passed this House unanimously. There was not one dissenting vote. It does much the same thing as House Bill 242 before you now, but in the interim time, what has occurred is after the bill passed, the governor had concerns, as the rest of us did, from the bill that we passed. There were some costs in there that really were not clearly defined of what would be the cost and where that cost would be placed as far as a burden on either state or local governments. So the governor recommended, I agreed, that we hold the bill up and let the commission that had been set up by the governor, he had a special counsel on criminal justice reform that was first set up by this House and served the year before, but he continued by decree, the governor's decree, to have this as a continuing body, and primarily for the purpose to look into and review our juvenile practices and see where reforms might be necessary. It was a bipartisan group. It also concerned many other agencies. I want to, first of all, Mr. Speaker, recognize those in the House who served on the council at the governor's request: Representative Stacey Abrams, Representative Mary Margaret Oliver, Representative Jay Powell, and Representative Willie Talton, and myself were those representing the House. But we also had assistance from Representative Jay Neal, who, although was not named one, he served as coming to many of the members and participated with the discussions. I'd like to also recognize Representative Rich Golick for his handling of House Bill 1176, which was the initial adult reform bill, and this year the handling of House Bill 349, which will be coming later before you. The state has completely replaced in this bill the Georgia Juvenile Code, which governs the state's responses to children in trouble and troubled children. House Bill 242 recognizes and reorganizes the code to make it easier to understand and apply modernized substantive provisions to reflect advances in research and practice in the field of juvenile justice and bring Georgia up to date with successful reforms modeled after other states such as Texas, Ohio, and Louisiana, who have also recently enacted substantial reforms in their justice system for children. The work was done through the governor's office. A great deal of individuals there were involved, and certainly the governor most of all, the Special Counsel on Criminal Justice, the Pew Center on the States, and the Annie B. Casey Foundation helped supply not only financial support, but did a great deal of the research to bring statistics and information to the Commission. The State Bar of Georgia, the Council of Juvenile Court Judges, the Prosecuting Attorneys Council, the Georgia Association of Criminal Defense Lawyers, Georgia CASA groups, the Department of Juvenile Justice, Department of Human Services, Department of Behavioral Health and Developmental Disabilities, the Association of County Commissioners of Georgia, attorneys who represent children, youth who have been brought through the system and also in foster care, and many, many more. You have on your desk a document which was handed out with a blue cover sheet, and on the back of it you have a list of 2 pages of individual groups that have been not only supported but involved in the preparation of this important bill and legislation. The recommendation of the Council included in House Bill 242 and the Governor's budget will save the state nearly $85 million by now between 2018 and will avoid the opening of 2 additional juvenile residential facilities by the state. It will further allow the state to reinvest a portion of these savings to expand the proven community-based programs that are being started with this bill and the appropriations by the governor. I'm going into a few details about the bill to try and explain the makeup of the bill and give you some insight as to why the bill is set the way it has been. Article 1 is a general provision covering principles as well as the juvenile code proceedings. It also contains your definitions. Oops. Lost my sheets over here, excuse me. Article 2 governs the creation of administration of the juvenile courts and how the appointment of judges are to occur. Article 3 relates to cases involving children who have been abused or neglected by the state and by adults responsible for their well-being. It renames deprivation of cases to dependency, as all other states refer to these cases. It shortens the timelines for certain hearings to help expedite resolution of these cases for the sake of the child and the family. Article 4 will govern the cases involving involuntary termination of the rights of a parent because of a parent's inability to safely and adequately care for the child. However, it strengthens procedural protection for parents in these proceedings and provides additional ways for children to stay connected and supportive adults after the parent's rights are terminated. It preserves a child's relationship with their siblings and other extended family until the child is adopted by another family. It allows a child who has not been adopted and is unlikely to be adopted to ask the court to reinstate his or her parents' parental rights under certain circumstances. Article 5 changes Georgia's approach to intervening with children who are currently considered unruly. This is termed now children in need, or CHINs, are those who have committed an act that would not be against the law but for the fact that they are children. As I mentioned earlier, runaways, truancy, such violations of that. Currently, court intervention with these children is similar to intervention in delinquency cases, and under Article 5, the bill creates a more holistic, service-oriented approach to these children and their families. Specifically allows status offenders to be detained only under very limited circumstances and limits the total time a child in need of services can be held in a secure detention. Article 6 addresses situations when children break the law, referred to as delinquency cases. It recognizes and clarifies the delinquency provisions of our current law and makes some substantial or substantive changes, including requiring use of standard assessment to aid courts determining whether placing the child in secure detention is appropriate. These are referred to as our detention risk assessments. In revising the Designated Felony Act to create 2 tiers of classes, a Class A and Class B felonies with different penalty options for the court that allow the judges to differentiate punishment according to the severity of the offense. Article 7 governs the way courts determine whether a child who is mentally incompetent is capable of whether a child is determined to be mentally competent and to participate in a delinquency case, or whether they're not competent. It requires a competency evaluation for a child under the age of 13 accused of committing a serious violent felony, and provides a range of responses for an incompetent child. Article 8 deals with parental notification on abortions. This is a standing provision of the law. It has not been changed by this act. It retains the same language and provisions we have under current law. Article 9 governs access to hearings and records in juvenile proceedings, and it further maintains what we currently have in our law. Article 10 relates to emancipation, which is a process by which a child becomes legally adult, even though it may not be yet 18 years of age. Article 11 renumbers provisions of the enabling legislation of the Office of Child Advocate, but makes no substantive changes. Let me close by pointing out House Bill 42 further requires that detention assessments, as I mentioned earlier, and risk assessments and risk and need assessments be developed, made available for use by intake workers and the courts, and be validated every 5 years. So this will be a continuing process. I think it's one of the things we've missed out on in under our current law and what our previous statutes have, because we did not have really a means by which oversight of our laws dealing with juveniles could be updated and changed from time to time based upon new practices. It further requires any Department of Justice juvenile justice contact for services to delinquent children be a performance-based contract that incentivizes evidence-based programs and services. Ladies and gentlemen, doing the right thing for our children is not a partisan issue. In fact, the governor this year has placed in his budget $5 million. One of the concerns has been, are we placing a burden on our local governments and local courts? I submit to you what we're going to be doing through the enactment of these various programs will be funded through the state, and the governor is starting out with, I'll call it seed money of $5 million to begin these programs, first in the areas where we find the greatest percentage of children are coming into our juvenile justice system for detention. Go to those areas and help set up and fund the programs that are needed to maintain the children in a community basis where they can be retained in their school, hopefully in their home, but in the community where the best care can be provided to them on a local basis. That is one of the major cornerstones of this entire program. Mr. Speaker, I'm reached the point I believe we're ready to take any questions, if there are any from my colleagues, and if not, I'll certainly ask for your favorable support to this very important legislation. It's probably one of the major pieces of legislation you'll be seeing during this session, and I commend it to you. Thank you, Mr. Speaker.
You looks like you have one question. Do you yield?
I do yield, Mr. Speaker.
Chair recognizes Representative Mickey Stevens for a question. Representative Mickey Stevens, to your right.
Good. I'm sorry. I'm losing it. I'll recognize. I'm sorry, I can't find Mickey Stevens.
He waves.
He waves. I'm sorry.
Okay, he waves.
Well, Mr. Speaker, there's no further questions.
There are no further questions.
This is an important bill, and I hope that, again, this House will pass unanimously House Bill 242. Thank you, ladies and gentlemen.
The gentleman has yielded the will. Is there any objection to the previous question on House Bill 242 being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 242 will vote yes. All those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 242. The ayes are 173, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed.